Okay, before I enter into testimonial evidence part 6 of this mini review, I'm going to just go through when the best evidence rule applies. So this would be first when a party seeks to prove the contents of a deed through witness testimony or other secondary evidence. 2, party seeks to provide the contents of contract through witness testimony or other secondary evidence. 3rd, party seeks to prove the contents of a will through witness testimony or other secondary evidence. This is all when those are 3 examples of when the best evidence rule applies. So 4th, in a breach of warranty case, a witness seeks to testify to the contents of the written warranty which she read. 6, nurse seeks to testify regarding the content of a medical record that she read. 7, in an obscenity or copyright trial for a book, movie, photograph, etc., party seeks to introduce a newspaper review or witness testimony. 7, in a case where P claimed D defrauded her by selling her a gown she claimed was an original Halvenshi, P seeks to testify that she found a label in the arm of the gown stating it was made at Elmart. Radiologist seeks to testify regarding the extent of P's injuries he found in x-rays he took without producing the x-rays. So the best evidence applies to those, but doesn't apply if D denies having made a contract with P. P may introduce secondary evidence to prove that a contract exists, but not its contents. Or secondly, witness may testify that he is 30 years old and married without producing the respective certificates. 3rd, witness may testify to testimony he heard at prior proceeding without producing a transcript. 4th, witness may testify that he is a real estate broker without producing his license, if not material to the case. 6, nurse who took vital signs may testify to them without producing a medical record. 7, party may introduce a chart summarizing the personnel records of 500 employees, if it's in a chart. And then 7, party may introduce a certified copy of a certificate of incorporation, the original of which is on file with the Secretary of State. And W may testify about a plane crash she witnessed despite the fact that the crash was captured on home video. P may testify that D delivered a deed to her by handing it to her, without producing the deed. So let's move on to testimonial evidence. A, competency of witnesses. Witnesses must pass tests of basic reliability to establish their competency to give testimony, but they are generally presumed to be competent until the contrary is established. Witnesses must possess, to some degree, 4 basic testimonial attributes: the capacity to observe, to recollect, to communicate, and to appreciate the obligation to speak truthfully. Federal rules of competency. The rules do not specify any mental or moral qualifications for witness testimony beyond these 2 limitations. 1, there must be evidence sufficient to support a finding that the witness has personal knowledge of the matter about which he is to testify. Note that proof of personal knowledge may consist of the witness's own testimony. And 2, the witness must declare he will testify truthfully. If a witness requires an interpreter, the interpreter must be qualified and take an oath to make a true translation. 2nd, modern modifications of the common law disqualifications. Most jurisdictions and the federal rules have removed the common law witness disqualifications for lack of religious belief, conviction of a crime, and interest in the lawsuit. Infancy, insanity, judge, and jurors come after that section, but within it. So infancy. The competency of an infant depends on the capacity and intelligence of the particular child as determined by the trial judge. Insanity, an insane person may testify, provided he understands the obligation to speak truthfully and has the capacity to testify accurately. Judge and jurors. The presiding judge may not testify as a witness. Likewise, jurors are incompetent to testify before the jury in which they are sitting. Jurors' inquiry into verdict or indictment. During an inquiry into the validity of a verdict or indictment, a juror is generally prohibited from testifying about what occurred during deliberations or about anything that may have affected a juror's vote, and the court may not receive evidence of a juror's statement on such matters. However, a juror may testify as to whether any extraneous prejudicial information was improperly brought to the jury's attention, whether any outside influence was improperly brought to bear on any juror, whether there was a mistake on the verdict form, or whether any juror made a clear statement that he relied on racial stereotypes or animus to convict a criminal defendant. The rationale for allowing this evidence is to permit the court to determine whether the defendant's Sixth Amendment rights to a jury trial was violated. Not every comment indicating racial bias will qualify. The court must find that racial animus was a significant motivating factor in the juror's vote to convict. Dead man acts. Most states have dead man acts, which provide that a jury or person interested in the event is incompetent to testify to a personal transaction or communication with the deceased when such testimony is offered against the representative or successors in the interest of the deceased. A person is interested if he stands to gain or lose by the judgment, or the judgment may be used for or against him in subsequent action. A predecessor in interest of the interested party is also disqualified. There is no dead man act in the federal rules, but a state act will apply in federal cases where state law under the Erie Doctrine provides the rule of decision, for example, diversity cases. Form of examination of witness. The judge may exercise reasonable control over the examination of witnesses in order to aid the ascertainment of truth, to avoid wasting time, and to protect witnesses from harassment. Leading questions. Leading questions, for example, questions that suggest the answer desired are generally improper on direct examination. However, they are permitted on cross-examination to elicit preliminary or introductory matter when the witness needs aid to respond because of loss of memory, immaturity, or physical or mental weakness, and when the witness is hostile. Improper questions and answers. Questions that are misleading, cannot be answered without making an unintended admission, compound, requiring a single answer to more than one question, argumentative, conclusory, cumulative, duly harassing and or embarrassing, call for a narrative answer or speculation, or assume facts not in the evidence, are improper and not permitted. Okay, so this is literally like everything, and I don't know where to find it in the code. Answers that lack foundation, the witness has insufficient personal knowledge, and answers that are non-responsive, do not answer the specific question asked, may be stricken. Use of memoranda by witness. A witness cannot read her testimony from a prepared memorandum. However, a memorandum may be used in certain circumstances. So, the form and examination of witnesses, improper questions and answers. So we've got misleading, compound, argumentative, conclusory, cumulative, unduly harassing, or embarrassing, call for narrative answer, or speculation, assume facts not in the evidence, and lack foundation, or non-responsive. So those are answers that may be stricken. So this is like my only source of this information besides like another book that I used in another class, which was not evidence. I barely knew that leading questions. I do know that leading questions are okay when the witness is hostile and on cross-examination, but these other 2 points, to elicit preliminary or introductory matter, or when a witness needs aid because of loss of memory, immaturity, or physical or mental weakness. I wasn't really aware of that. Learned it yesterday, though. So, exam tip. Anytime you encounter an exam question in which a witness consults a writing, keep in mind the differences between refreshing and recorded recollection. The fact patterns are very similar and could be confusing if you have not thoroughly memorized the distinguishing features. Present recollection revived, refreshing recollection. A witness may use any writing or thing for the purpose of refreshing her present recollection. She usually may not read from the writing whenever she actually testifies because the writing is not authenticated and not in evidence, and thus there's no hearsay concern. So I don't really think that's right because I just wrote down some requirements that the writing can't just be anything, use any writing or thing. Incorrect. Actually, I think it has to have been produced either during or right after the event. Anyhow, the next section, within the present recollection, revived, refreshing recollection, is inspection and use on cross-examination. Whenever a witness has used a writing to refresh her memory while on the stand, the adverse party is entitled to have the writing produced at trial, cross-examine the witness thereon, and introduce portions relating to the witness's testimony into evidence. If the witness refreshes her memory before taking the stand, an adverse party is entitled to such production and inspection only if the court decides that justice requires it. And then before I go into this nice little table on page 19 showing the differences, I'm going to go into the second part, which is past recollection, recorded recollection. So maybe I'm mistaken earlier, but where a witness states that she has insufficient recollection of an event to enable her to testify fully and accurately, even after she has consulted a memorandum or other record given to her on the stand, the record itself may be read into evidence if a proper foundation is laid. The foundation must include proof that the witness at the time had personal knowledge of the facts of the record was made by the witness or under her direction, or was adopted by the witness. The record was timely made when the matter was fresh in the witness's mind, and the record accurately reflects the witness's knowledge, i.e., witness testifies that it was accurate when made, and the witness has insufficient recollection to testify fully and accurately. So actually, all of these things are what I just wrote on a note card yesterday that I thought had to do also applied to recollection. Oh my God. Present recollection, reviving. Refreshing recollection. Here we're talking past recollection, recorded recollection, and that's when finally all these elements are being brought to my attention. So I wrote down recorded recollection. Okay, so the elements that I said applied to recorded recollection, not refreshing your recollection. So I'm just going to write here page 19 through 20 of Conviser's Barbri outline to compare, because here I had 4 elements in recorded recollection: that the writing made by the witness near the time of the event. So that was there. Witness memory cannot be revived. That was the first. No. That was not even an element, but it was in the paragraph. And then about something that the witness once had knowledge of. So personal knowledge is there. And sufficient evidence that the record was accurate when made. So made by the witness is kind of a subpart of that. And or adopted by the witness. And timely made, that's already here, accurately reflects the witness's knowledge. Accurate. All right, that is an element that they have insufficient memory. Okay, so this is now complete. How does it differ from the earlier recollection refreshed? All those requirements are not necessary because that stuff's not going before the jury and it's not being read. So I suppose that'll work. Although the record may be read into evidence and heard by the jury, it cannot be admitted into evidence as an exhibit unless offered by an adverse party. While this may seem like a minor point, it tends to come up on the bar exam yesterday. Let's look at this table. So for the present recollection refresh, which is the first definition I gave, any writing may be used to refresh a witness's memory. Things other than the writing may also be used, such as a photograph. If the witness cannot read from the writing while testifying, they cannot read. That's not an if, that's a definite. And there is no hearsay problem because the writing is not offered into evidence. So recorded recollection, only a record that meets several foundational requirements. For example, timely made by the witness cannot remember, even after reading the record, and the record itself is read into evidence, but is not received as an exhibit unless offered by an adverse party. And this is hearsay, but it falls within a specific exception to the hearsay rule. Whereas with present recollection refreshed, there is no hearsay problem because the writing is not offered into evidence. So I don't understand their comment here about how this is not hearsay and it is hearsay. I feel like that's case specific. But anyway, I'm going to read the opinion testimony, which is like subpart C under the testimonial section. The general policy of the law is to prohibit admissibility of opinion evidence except in cases where the courts are sure that it will be necessary or at least helpful. Opinion testimony of lay witness, general rule of inadmissibility. Opinions of lay witnesses are generally inadmissible. However, there are many cases where no better evidence can be obtained. In most jurisdictions and under the federal rules, opinion testimony by a lay witness is admissible when it is rationally based on the witness's perception, helpful to a clear understanding of the testimony, or helpful to the determination of the fact and issue, and third, not based on scientific, technical, or other specified knowledge. Specific or situations where opinions of lay witnesses are admissible. An opinion of a lay witness is generally admissible with respect to the general appearance or condition of a person, the state of emotion of a person, the matters involving sense recognition, voice or handwriting identification, the speed of a moving object, the value of his own services, the rational or irrational nature of another's conduct, and intoxication of another. So situations where opinions of lay witnesses are not admissible are opinions of lay witnesses are not admissible with regard to whether one acted as an agent or whether an agreement was made. And then here's a little bit of a close-up on what is really meant by any of these things, like appearance or condition of person. He was about 80 years old or seemed ill, state of emotion, angry or distraught. Matters involving sense recognition, the suitcase was heavy, he smelled of garlic, a voice or handwriting identification, it sounded like Mark, that's Fran's handwriting. Speed of a moving object, very fast, at least 60 miles per hour. Value of own services, my time is worth $50 an hour. Rational or irrational nature of another's conduct, he was acting crazy. Intoxication, she was slurring her words and smelled of gin, she was drunk. Foundation may be required for that intoxication one. So opinion testimony by expert witness, and this is where I really kind of might want to stop because it's about a halfway point, but I also really need better understanding of expert. witnesses. An expert may state an opinion or conclusion provided the following requirements are met. The evidence must be relevant and reliable. Specifically, A, the subject matter must be one where scientific, technical, or other specialized knowledge would assist the trier of fact. And this is, so one, the evidence being relevant and reliable, like i.e., like not hearsay, but like was it given? Is the expert allowed to testify on just sitting there in like observing the order of the case being presented and then make a expert opinion? Can it be on hearsay? Does it have to be does it it's tough making that determination, but relevant and reliable is what they're going with here. I've heard a lot of different things is what I'm ultimately trying to say. Specifically, the subject matter must be one where scientific, technical, or other specialized knowledge would assist the trier of fact. The opinion must be based on sufficient facts or data. The opinion must be the product of reliable principles or methods, and the expert must have reliably applied on the principles and methods to the facts of the case or scientific evidence. The Dauber factors for reliability include $10 to get to church here. Perhaps I ought to get it together. So this is on page 22 of Conviser. And then I'm going to need another one for the Dauber factors of reliability include those Dauber factors of reliability include whether the theory or technique has been tested, whether it has been subject to peer review and publication, its known or potential error rate, the existence and maintenance of standards controlling its operation, and whether it is generally accepted in the scientific community. The witness must be qualified as an expert, possess special knowledge, skill, experience, training, or education. The expert must possess reasonable probability regarding her opinion. The opinion must be supported by a proper factual basis. The expert's opinion may be based on one or more of three possible sources of information: A, personal observation; B, facts made known to the expert at trial, often by hypothetical question; or C, facts not known personally, but supplied by her outside the courtroom and of a type reasonably relied upon by experts in the particular field. Unless the court orders otherwise, the expert need not disclose the basis of the opinion on direct examination. However, the expert may be required to disclose such information on cross-examination. Opinion on ultimate issues. Under the federal rules, an expert may render an opinion as to the ultimate issue in a case. However, in a criminal case in which the defendant's mental state constitutes an element of the crime or defense, the expert may not, under the federal rules, state an opinion as to whether the accused did or did not have the mental state in issue. Authoritative texts and treatises. An expert may be cross-examined concerning statements contained in any publication establishes reliable authority, either by the testimony of this expert or another expert, or by judicial notice. Under the federal rules, these texts and treatises can be used not only to impeach experts, but also as substantive evidence, subject to the following limitations. An expert must be on the stand when an expert is read from a treatise, and the relevant portion is read into evidence, but is not received as an exhibit. So, I've received so many MBE questions on this point. It's, fantastic that they're finally speaking to it, exactly as I need to hear it in order to answer these questions.